It's not uncommon for pre-trial criminal proceedings to go on for over a year or even up to 2 years or more, especially if the defendant is not being detained. If the defendant's in jail, it's a whole other story. You want the proceedings to happen as rapidly as possible. But if they're not, they could drag on for a very long time. There are advantages and disadvantages to this. I would say the number one advantage is that witnesses and alleged victims and the people involved in the incident giving rise to the charges, a lot of times they become disinterested, they have a change of heart, they move, they become harder to communicate with, and it makes it a lot harder for the prosecution to build a case or make a case against you. The biggest downside, in my opinion, is that the charges are hanging over your head all of that time, right? And you're released on your own recognizance, all right? The judge hasn't set bail, or if he has, you've paid it. Now, if you get arrested again, you're going to be in big trouble, and the prosecution is going to ask that your bail be revoked. If you're released on your own recognizance, the judge may impose bail on the new charges, and it's just not a bad situation. Or it is a bad situation. It's not a good situation to be in. So you need to keep that in mind. If you delay things, it could very well weaken the prosecution's case, but it could also set you up for even bigger problems if you run into trouble again within that year or two of postponing things. If you have any thoughts, let me know. Send me an email, and I've written a blog post, and I'll put it in the description below.